Well, last one of the day, and it's one of the most interesting topics I think you'll hear, which is a very hot topic now. We've used it in our practice with this firm, Fein Such, and this is Stephen Loeb, who's going to talk to us about trust decanting.
Good afternoon, everyone. Thank you very much for having me, Reed. I want to start today by saying this is not the wine decanting class. The reason that, for the most part, it's called trust decanting is because if you think about what this is at its most basic source, we're dealing with a situation where we have an existing trust which doesn't work anymore. And we're looking to do almost a do-over, to take the assets in the existing trust and pour them into a receiving trust or a new trust. And to cure the problem, we're going to take all of the good in the old trust, bring it to the new trust, and leave the sediment, that's where it comes from wine decanting, the old terms in the old trust. So for irrevocable trust, one of my clients that I just actually completed a decanting with said to me, if this is an irrevocable trust and I can change it, isn't it like an oxymoron? And the answer is, to an extent, yes. It is like an oxymoron. We're taking an irrevocable trust and we're making it borderline revocable to an extent. We're changing certain terms in the trust. What the client also said to me once we completed the trust decanting was, hey, Steve, that was great. You were the second most important attorney I ever met. And I said, I didn't know if to take that as a compliment or an insult. And he said, my criminal defense attorney was my most important attorney that I ever met. It is very important to note between different types of decanting. Statutory decanting, which New Jersey does not have. Decanting out of the document itself if the trust has terms allowing for the decanting. Or common law decanting, which is in New Jersey, which we actually have in the state. This is different than a trust modification or a trust construction action where you go into court and you actually get a judge to modify the trust. This is sometimes it's a less invasive approach. If you, for some reasons in some states, you don't need to give notice to beneficiaries to do that. We're going to talk in a little bit about fiduciary liability. That's a whole other issue, but it gives you multiple options. So on your bucket list should be trust decanting or as a trust modification. Can we do something with this trust? In New Jersey, we have had pending since June 9th, 2008, the Uniform Trust Code has been pending at the committee level. There's an Assembly bill and a Senate bill out there. It has died every year in committee. What that would allow, if we were able to do that, would be via consent. The grantor, if alive, the settlors, and the beneficiaries could modify the trust documents without going to court, without decanting. It would be a nice technique to be able to use. We technically, under New Jersey law, cannot do it. In New York, we have a decanting statute, which we're going to talk about in a little bit. Reasons to decant. These are just some of the reasons. Not all the reasons, but these are some. Some of these I've dealt with. Some of these, some of my colleagues have dealt with. Extending the term of a trust. You have a trust. Age distributions, typical older trust. A third at 25, half at 30, balance at age 35, outright distributions. Doesn't work. Let's say at age 35 or at 33, one of your clients is going through a divorce or has a creditor issue, declaring bankruptcy, you name it. What can we do to change the terms of the trust to extend the trust? This is where trust decanting comes into play. I have a situation right now where I have an irrevocable trust, grantor is alive, and there's an S corporation stock is inside the irrevocable trust. When that grantor dies without qualified subchapter S election language or electing small business trust language, we will blow the S election. So when they came into my office and I said, yes, there isn't qualified subchapter S language in the trust, one of our options, which I think will be the option, is to decant to a new trust and to place in the new trust qualifying subchapter S language in the instrument itself. Third issue, which is becoming a real important issue, there was a case most recently in New York, which I'm going to try and get to at the end, in 2013, dealing with this situation. When trust is created, the beneficiary doesn't have special needs issues. Going on later in life, they develop special needs issues. One option today is to decant the trust, and I'm going to leave that to a little bit later. Move trust situs. If the trust document does not allow you to move trust situs, simple as that, change from New Jersey to Florida to another jurisdiction, we have an issue. What I like to do typically is see if we have language to do that. Sometimes if I'm dealing with a New Jersey trust, I want to sort of forum shop. I want to go to a different state and say, hey, can I go to that state and use their statutory decanting language in order to do that if we can't do it in the trust document itself? Combine, separate trusts. To convert distribution terms from health, education, maintenance, and support to discretionary purposes for asset protection reasons. Adjust powers of appointment. We may want to do that in order to prolong the estate tax situation in order to not have an estate tax situation at the beneficiary's death. We have to be careful if we do that because we may run into generation skipping transfer tax issues if we have a dynasty type trust. Two issues which never happen for attorneys: drafting errors and clarifying ambiguous terms. If we don't have a decanting statute, we are left if we have, let's say we have beneficiaries that don't read the trust our way. I have this situation currently. You either go to court or you all agree to decant the trust if decanting is a possibility. And then changing trustee provisions, which is a big issue. If you have a trust that doesn't have an ability to name new trustees, and that trustee, the existing trustee, either is reaching retirement age, passes away, there needs to be an ability to name a new trustee. Again, the other option is going to court. We talked about, again, decanting is taking assets, moving them from one trust to a new trust, leaving the bad sediment in the old trust. How decanting specifically works, and this is what I think it's very important to look at. What is the governing law? Is the law of the trust New Jersey, New York, Nevada, Delaware? That's step one. Are there discretionary distribution terms or powers of appointment inside of this trust? If there are certain things we can do. If there's restrictive language, we may not be able to decant. Is there language authorizing the trustee to administer assets under the terms of the new trust? Those are things we need to look at to determine where we're going with this. Statutory decanting. This is maybe either the easiest or the second easiest way to decant a trust. This trust must be sitused in a state that has a decanting statute. New Jersey doesn't have it, so we cannot rely on statutory decanting in New Jersey. But remember what I said. Maybe the trust has an ability to move to a different situs. If it does, we maybe move the trust to New York. New York has a decanting statute, and we decant from there. So yes, if we do have a decanting statute, each state's decanting laws differ from one another. There are 22 states that have a decanting statute. What no state will allow you to do is to name new beneficiaries. And there was a case, the Henry Johnson case, which came out 2 months ago. In New York, you had a trustee through a divorce. The creator of the trust was wife. Husband and wife were getting divorced. We had beneficiaries of the common marriage. What the trustee was trying to do was add the fathers, the creator of the trust, issue and cousins and other people inside the trust. The court in New York that has a decanting statute said, no, you cannot be that broad. So it's very important to look at who the beneficiaries are of the trust and not deviate from that.